Alright, good morning everybody. Welcome to the week 3 video lecture. So we start off with kind of a quick run through of Chapter 3 of Just Mercy. Chapter 3 is Trials and Tribulations. In it, Bryan Stevenson runs through Walter McMillan's arrest and his pretrial, being sent pretrial to death row and that experience. He really talks about some very vivid descriptions of what it's like to be on death row, what it's like to sit on death row knowing an execution is about to occur, and just about a botched execution. So some things to think about are why Bryan Stevenson is setting up all of this detailed information about death row. I think in part it's to humanize Walter McMillan and his struggles and to humanize other death row inmates. But it's also kind of getting back to the title of the book being Just Mercy, about is this cruel, is this humane, those big picture questions. Also, some of the language in this, the use of the N-word repeatedly and things like that are also designed to draw conclusions about how much Walter's race mattered at this time, how much it impacted his ability to have a fair trial. So as I read through the journals were great on this chapter. I hope you guys keep up what you're doing. So shift focus over to the course pack. We are starting Module 2 at this point, and Module 2 is all about the Fourth Amendment. So the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized." So this works as two separate clauses. The first clause of the Fourth Amendment is the warrant clause, this bottom part. This tells us the preference is for law enforcement to get a warrant, that they swear by oath or affirmation with probable cause. Probable cause means that it's likely a crime was committed, this person committed the crime, and there's facts to support that. The second part is a protection against unreasonable searches and seizures. This inherently means that the Fourth Amendment does not prohibit government actors from engaging in a reasonable search and seizure. And so a big part of our time in the Fourth Amendment is going to be spent dealing with these delineated exceptions to this reasonableness requirement. There are certain types of searches the Supreme Court has said are always reasonable, like a stop and frisk, like consent to a search, like the plain view exception. So those things are inherently reasonable, so they don't violate the Fourth Amendment. As to how the Fourth Amendment works, there's a great flowchart that kind of deals with how to work through some of these ideas, and later today I'll be posting a different flowchart. Did a seizure occur? If not, the Fourth Amendment is not violated. Was there reasonable suspicion or a reason for the stop? Did the officer's frisk comply with the Fourth Amendment? Was there probable cause? So this is a really great kind of picture of how the process works. And I have a different one that I like that I'll be posting for you later today as well. And the one that I'll be posting for you later today, you can almost slot in every case we're going to read and explain why they're there. The Fourth Amendment regulates a lot of our day-to-day police citizen interactions. It regulates when a police officer pulls you over for a traffic violation. It regulates when a police officer comes to their house. As far as the Fourth Amendment, we see most of it in criminal courts, and if a police officer violates the Fourth Amendment, the remedy for that violation is the exclusionary rule. And this is something that we saw with Dalry Mapp's case in Mapp v. Ohio. The remedy for the Fourth Amendment violations that occurred, the search without a warrant, was that all the evidence they obtained, those pornographic magazines, were excluded under the Fourth Amendment. This means that evidence is being thrown away because the police officer violated the defendant's rights. This is not actually in the text of the Fourth Amendment, but it has been around a long time, since the 1914, and it's applied to the federal government. And the purpose is to reduce police misconduct. The thought being, if a police officer knows their evidence will be thrown out, then they will hesitate before they break someone's constitutional rights. As far as search warrants go, we aren't going to spend a ton of time on it, but this is kind of the basic information. The officer needs to have probable cause. Examples of probable cause are the nature of the crime, memory, personal knowledge. Now, something I do want you to look through this week and make sure that, and ask any questions you might have, are the exceptions to the warrant requirement. These types of searches are inherently reasonable. Consent, plain view, search incident to arrest, and exigent circumstances, the automobile, and hot pursuit. Additionally, stop and frisk. These two video presentations here are really excellent. So if you have any questions, look through and definitely send an email. Beyond that, we have 3 cases, and just a quick example. Consent is if the officer says, hey, do you mind if I take a look around? And you say, go ahead. You have given the officer consent. Plain view is when the officer is legally allowed to be where they are and they see evidence of a crime. If that occurs, then you have given permission. Search incident to arrest is the body pat down in anywhere the defendant could reach. Exigent circumstances are the hot pursuit of a fleeing felon, destruction of evidence. Automobile exception applies when you're in your vehicle, and stop and frisk is a basic encounter. All right. If you have any questions, let me know. I look forward to hearing from you.